आवाज आ रही है इससे? हेलो हेलो चित्रा के लिए अरे तुम लोग लाइव हो भाई, रुक जाओ 2 मिनट। हो गया होगा लाइव में।
बाकी टूटी है।
मैडम टेस्ट लाइव करो।
बंद कर दो टेस्ट।
हां पॉज है।
मैम
वो तो हो जाएगा 1 मिनट में हो जाएगा।
हां जी, एक लैपटॉप वहां रखे हैं जो पीछे वाला है, वो वहां से चल पाएगा।
कौन सा लैपटॉप?
कोई भी जिसमें कोई भी एक हम वहां रखते हैं वहां से
ये मतलब लाइव
नहीं लाइव वाला तो यहीं पे होगा। जो पीछे तो चला रहा है ना वो अलग लैपटॉप चल रहा है ना।
हां बट इसका ये पोर्ट है।
कनेक्टेड वहां से नहीं चल पाएगा वायरलेस यार मैं
और साइड पे
वो हैंडलमेंट खाने पड़ी है, खा के टैग तो भाई
वन साइड है खाने का। अभी भी कुछ दिक्कत है? ये अभी ठीक है तो आई थिंक चल जाएगा। बहुत कम लैग है बीच में नहीं हो।
एक था शायद मैं लेकर
कौन प्रोजेक्ट है इतना इन्वेस्ट कर रहे स्टार्ट है
तेरी कितने अच्छे
मेरे
3.5 सेटअप करा के जाना है। पॉज है ना अभी?
ये पिक्चर क्या है?
एक ना तुम में से कोई एक दूसरा बैठ जाओ।
नहीं ठीक है।
हेलो 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 हेलो
ये देखो अदर एक बोतल नीचे
मैक्सिमम
चाहिए तो ले लो।
हेलो
एक ही तरफ भाई से थोड़ा बहुत ठंडा देख ले
भाई अपन ना टाइमर
हेलो
मे बी स्टार्ट
हेलो हेलो हेलो
तू यहीं बैठा है ना, जाएगा नहीं ना तू नहीं तो मैं ना फोटो हेलो हेलो किसी से
फोटोज तो वो ले रहा है
नहीं हम वैसे करेंगे
हेलो
और लोग हैं वीडियोस वगैरह बनाएंगे।
हवा निकालो।
यहाँ से आए चलो निकालो। एक इसको ये सीआरएम है, इसी को पूरा बता दे कैसे करना है।
अच्छा ये ले
हेलो हेलो हेलो
अभी और नहीं किए वैसे हो गया ना वो तो ले आया
हो गया ना? हां
बट रख ले इधर से
फिर तो ठीक है। फिर क्या
तो इधर रख दो हां इधर रख दो
ठीक है। हम ना टाइमर भी चलाएंगे, स्टॉप वॉच चलाएंगे। व्हाई? क्योंकि टाइमर में तभी तुम्हें ये नहीं पता कि कौन सी टिक करता है। स्टॉप वॉच में बढ़ता रहेगा। जैसे कि मान ले 23 मिनट लिया किसी स्पीकर ने, 23 के बाद वो कह रहा है कि 2 मिनट की एक्सटेंशन चाहिए, 20 मिनट में स्टॉप वॉच जैसे 2 पे राइट एक का प्रोसेस है नहीं वो स्टॉप वॉच की समथिंग की जहां पे वो दिख जाएगा टाइम नहीं करना टाइमर में क्या बैठा है वो टाइमर में लिखा है। मेरे को टाइमर भी पता है नहीं कौन सा टाइम लगेगा।
सी anyway when the speakers come in they tell us कि we are going to speak
तब सेट करना
just take 18 minutes 2 मिनट
एक्सटेंशन और नहीं है क्या?
आपके टीम
अब करना
तुम दोनों यहीं बैठो।
मुझे जब देखा ना सेविट्री
सर नेबर नो ग्राउंड फ्लोर अटैच करा एक सेकंड टीम को निकाल दो पता नहीं
एक बोल और लाइयो एक में देख रहे हैं सब बड़े एक बार बोल रहे हो
मैंने बोल दिया था आ रहे हैं बात आ रहे हैं
पैर तो ऐसे कुछ दिखने वाले नहीं थे। उसको कैसे मारा मैं तो प्रोजेक्ट ही खड़ा हुआ।
ये कंफर्म है ना NLUO as a claimant, claimant removal NLUO और respondent NLUO.
All the best.
Members of the Arbitral Tribunal, participants, and all those who have joined us here today as well as virtually. It was with immense pride and excitement that I welcome you to the finals of 11th National University Odisha Bose Mitra and Co. International Maritime Arbitration Moot 2024. After intense arguments and counter-arguments, discussion, over the course of several days and rounds, we have finally reached the ultimate stage of this year's competition. It's time to the top two teams compete for the title of champion. The proposition for IMAM 2024 is an interesting case of maritime arbitration between Beta Pte Limited and the claimants, which is represented by National Law University, Delhi, and Gamma EPE, the respondent, being represented by National Law University, Jodhpur. It is my honor to announce the esteemed panel of arbitrators for the final rounds. We have here with us today Mr. Ashwin Shankar, partner of Chambers of George Rebello, Mr. Adit Krishnamurthy, partner of Bose Mitra and Co. Mr. Joy Thathiu, managing partner, Calidus Legal. We shall begin with the rounds. We shall now begin with the rounds. Everyone is requested to keep their phones on silent and avoid any other disturbances during the rounds. Once again, I wish the participants best of luck and we look forward to hearing your arguments. Thank you.
Did not have a valid lien over Sahoo about ODSP and therefore was not entitled to recover the unpaid charter hires from the claimant. The tribunal is clear with the division of the issue. May I proceed with my submission on the first issue? Must oblige tribunal. Commencing with the first issue, members of the tribunal, we submit that the claimant has a title to sue the respondent in the present matter since the contractual arrangement evidenced by the bill of lading dated 1st February 2024 renders the respondent as a contractual carrier. I will be making this submission on 3 counts. Firstly, the issuance of bill of lading dated 1st February 2024 establishes an implied contract between the claimant and the respondent. Secondly, the signature by the agents of the respondent renders the bill of lading an exclusive contract between the claimants and the respondents. And thirdly, that the claimants have a title to sue the respondent under the principle of third-party entitlement in good faith. May I start with my submission, members of the tribunal? Thank you. Coming to the first part of my submission, members of the tribunal, we submit that the issuance of bill of lading dated 1st February 2024 establishes an implied contract between the claimant and the respondent. In making this submission, I would like to bring forth the case of Brand versus Liverpool, where it was clearly held that where goods are loaded on board a ship, the bill of lading issued to the consignor with regards to those goods establishes an implied contract between the consignor and the party issuing such bill.
Council Grant versus Liverpool is good law with enactment of Carriage Equal Specie Act 1992. So
Yes.
what you have to do is to make out a case for title to sue. You have to bring yourselves within the rigors of Carriage Equal Specie Act.
Without tribunal, yes.
So go to the second submission on that part.
Much obliged, arbitrator. Coming to the second submission, members of the tribunal, we submit that the signature by the agents of the respondent.
No,
on
answer my question. How is it that you come with Carriage Equal Specie Act 1992?
Your tribunal, we come under the Carriage of Goods by Sea Act by virtue of Article 2.1 of the Carriage of Goods by Sea Act. Article 2.1, as the lawful holders of the bill of lading, the Carriage of Goods by Sea Act provides us with vests in us all rights of suit with regards to breach of.
But how is it that you are a lawful holder? So read this section dealing with lawful holder of present meaning and explain as to how you fall within the rigors of that section.
Of the tribunal, we fall within the rigors of the such section because section 2(1)(a) provides that the lawful holder of the bill of lading shall, by virtue of becoming holder of the bill of lading, I have skipped part B and part C, as the case may be the person to whom delivery is to be, have transferred to and vested in him all rights of suit under the contract of carriage as if he had been a party to the contract. My co-counsel will in his submission clearly show you how we are the lawful holders of the bill of lading, and therefore, by virtue of section Article 2(1) of the Carriage of Goods by Sea Act, we are entitled to all rights of suit under the present case.
Okay, so this will be dealt with your co-counsel.
Yes, members of the tribunal. May I proceed with the submission, members of the tribunal? Members of the tribunal, we submit that the signature by the managing agents of the respondent in the present case renders the bill of lading an exclusive contract between the claimant and the respondent. Members of the tribunal, to establish this, I would like to point out the case of Samuel versus West Hartpool Co., where it was clearly held that where an agent or employee of the ship owner signs the bill of lading, such a bill of lading has to be construed as the ship owner's bill, therefore rendering the ship owner as the contractual carrier. Additionally, such a signature leads to the contractual disappearance of the time charterer, rendering the contract solely between the ship owner and the holder of the bill of lading. Thereby, members of the tribunal, the signature by the agents of the respondent in the present case leads to the contract being solely between the respondent and the claimant. Therefore, we have a type. Therefore, by virtue of breach of that contract by non-delivery of the goods, we have a right to sue the respondents in the present part. Now, members of the tribunal, the respondent may here argue that the other stipulations in the bill of lading, including the marking freight prepaid and freight payable to Delta, sorry for the mispronunciation, Mr. Arbitrator, freight payable to Delta and freight prepaid reverse such presumption created by the signature of the agents of the respondent. To this, we respond that it has been very clearly held in the case of the Stars Inn that with regards to the identity of the carrier, it is the signature on the front side of the bill of lading that has to be given the prime significance. Members of the tribunal, in the present case, since the prime significance has to be given to the signature on the front side of the bill of lading, the very act of signature by the agents of the respondent renders the bill of lading a ship owner's bill, thereby leading it to be the contractual carrier. Now, the respondent may also argue that the booking note tendered by Delta renders Delta as the contractual carrier, thereby absolving the present respondent of all liability in the present case. To this, we respond that such a submission would be bereft of any legal basis. Firstly, if I could ask the tribunal to please refer to the booking note. Members of the tribunal, the third stipulation from the bottom, if I could read for the tribunal. It is hereby agreed that a contract contained in this booking note shall be performed subject to the terms of the cogent bill of lading, which shall prevail over any previous arrangement. Therefore, a expressed signature by the managing agents of the respondent in the present case supersede any arrangement that has been contained in the booking note. Additionally, even in absence of any such stipulation, it has been very clearly held in the case of Pyrene versus Scindia Navigation and Co. that where an original contract is constituted before loading of the good on the ship, the terms of such a contract are subservient to the terms of the bill of lading which has been issued once the goods have been loaded on the ship. Therefore, members of the tribunal, it is the respondent that are rendered the contractual carrier in the present matter. Now, members of the tribunal, coming to the third part of my submission. We submit that even if the tribunal were to reject my previous submission and hold that the booking note is of particular relevance with regards to the identity of the carrier, still, the claimant has title to sue the respondent under the principle of third-party entitlement in good faith. Members of the tribunal, this principle has been enshrined in the case of Manchester Trust Limited versus Furnace Wilsey and Co.
Are you saying that even if it is a charterer's bill, you still can sue them as a third party?
That is not a precise submission, members of Mr. Arbitrator. But a precise submission is even if the tribunal were to hold that the booking note is of relevance to the identity of carrier, such a booking note is not relevant to the contractual status between the ship owners and the third party bill of lading holder in ignorance of any arrangement created by the booking note. Here I would like to cite the case of Manchester Trust Limited versus Furnace Wilthy & Co., where it was held that any arrangement which renders the agents of the ship owner as the agents of charterer for the purpose of signing of the bill of lading, such a stipulation is only relevant to the relationship between the ship owner and the charterer. It does not prevent a third party holder of the bill of lading from construing such a bill as a ship owner's bill in absence of any knowledge of such stipulation or such arrangement. So in the present case, it had to be brought to the explicit notice of the claimants that the booking note rendered the charterers as the contractual carrier. The failure to do so enables the third party holders of the bill of lading, that are the claimants in the present case, to construe such bill of lading as the ship owner's bill, and therefore hold the ship owners liable for the breach of the contract. To the tribunal, this brings me to the end of my submission of the first issue. If I may be of no further assistance to the tribunal on this issue, may I move on to the issue of validity of the lien? Much obliged to the tribunal. Members of the tribunal, commencing with the second issue, we submit that the respondent did not have a valid lien over cargo aboard ODSP and therefore was not entitled to recover the unpaid charter hire from the claimant. I will be making this submission on 3 counts. Firstly, common law lien over cargo is not operational in the present case. Secondly, contractual lien under the charter party is not incorporated into the bill of lading. And thirdly, even if the lien provision under the charter party is incorporated into the bill of lading, the very language of such section does not provide for its exercise on the present claimants. The tribunal is clear with our broad submission. May I move on to my first submission? Thank you, Mr. Arbitrator. Is there a concern? Thank you, sir. Coming to my first submission, members of the tribunal, we submit that common law lien over cargo is not operational in the present case. Members of the tribunal, it is a well-established principle under English common law that a ship owner has lien over cargo for payments pending under a contractual arrangement. We even accept that such a right extends to cargo belonging to third parties, including the bill of lading holder, that are the claimants in the present case. But members of the tribunal, it is very pertinent to note that such a right is subject to one restriction, as has been placed upon it in the case of Dakin versus Austin. If I may read directly from the case, it was held in that case that common law lien is only operational when the freight is payable at delivery. When the freight is paid in advance, the contractual variation of the common law principle extinguishes its operation.
I don't agree with your submission because if you look at the Manohar case,
Yes.
lien was exercised for unpaid demurrage.
Yes.
The owner of the good was not personally liable for demurrage. But nevertheless, because the lien clause was incorporated, the House of Lords held that until the demurrage amount is paid, the shipowner has a right to exercise a lien, even though the party whose property over which the lien is exercised is not personally liable. So what do you say for that?
Members of the tribunal, the Myanmar case concerned the contractual lien. But I am currently referring to the common law lien, as I will argue in my next submission.
So are you trying to say that, let's say there is a case of subbailment. I give my car to X in turn gives it to Y for repairing, okay? Now I am the owner of the car,
Yes.
the warehousing agent has repaired my car,
Yes.
but when I go and ask the warehousing agent to give back my car, the repair guard, he basically says until my dues are clear, I am not going to give it. Can't the common law lien be exercised to that effect as an AD for services rendered to the goods?
Members of the tribunal, it is a very submission that common law lien is only operational. It would be operational in the case you just stipulated, but it is not operational in the present case because freight has been paid in advance. Where freight is paid in advance, the contractual variation of the common law principle extinguishes its operation. Now, if I may ask the tribunal to please refer to the facts of the case. Members of the tribunal could refer to paragraph 2 of the present fact company. It has been clearly held that the bill of lading was issued on 1st February 2024, naming Alpha as the shipper. Now, if you would come to paragraph 3, it says that Alpha on 1st February paid the freight of 1,025 12500 to delta. That is our free obligation under the present bill of lading contract, and by series of endorsement, alpha was the original shipper. By series of endorsement, now delta, the lawful holder of the bill of lading, as my co-counsel will prove in a few minutes, is not, since the freight has been paid in advance under the bill of lading contract.
That's irrelevant now. So the point is not that they are liable to make payment of freight. It's only says that they are liable to make payment of freight. The issue here is that you have outstanding dues payable, and you are entitled to, you in the sense the carrier is entitled to withhold to the goods until his dues are cleared. So that is according to us, in common law, you can exercise a right of lien over a third party, especially if you say that the person who has given you these goods had ostensible authority. The same logic of a person who repairs my car. Okay? I own the car, somebody else gives the mechanic my car to repair it. That person has ostensible authority to contract on my behalf with you and to bind me to that contract. That's my case. And even as a matter of common law.
The very right that Mr. Arbitrator has talked about is derived from the contract here, that which is the charter party. If we come to clause 23 of the charter party, members of the tribunal, we see that the lien under the current case has been provided to the ship owners under the clause 23 of the charter party. Now here I would like to cite the case of the Spiros Sea, where it was clearly held that where a charter party reserves a right to lien for payments pending under it, such a right cannot be exercised on the bill of lading holder unless the bill of lading incorporates such lien. Now, members of the tribunal, if I could request you to come to the bill of lading reverse side, I may read the first condition of carriage for the tribunal.
Before you read, could you just explain me what exactly the lien under the common law is? What is the lien?
Sir, the lien is the right to retain cargo for payments pending under this arrangement.
I'm talking about the contractual obligations.
What is it?
I'm talking about the contractual obligations between the parties.
Under the current charter party.
Right.
Yes.
That is clause 23.
Yes, sir.
It's a man-made contract, isn't it?
Yes.
Correct? So if you look at the English law of contract, what exactly the lien speaks about?
The English law of contracts talks about lien as a right to retain cargo or retain goods that are in current possession of us, our current possession, for a payment that is pending under some arrangement.
So that means the lien can be exercised even with a third party who is not a contractual obligation that terms of contract, isn't it?
Yes, but here the very explicit terms of the charter party provide that owners shall have lien over all cargoes, sub-hire, sub-frees, belonging or due to the charterer or sub-charterer.
I agree. I have no dispute on that. Clause 23, I agree. I'm talking about, do you think if there is any kind of a conflict between a lien under the common law principle, under the English law of contract, and a man-made clause under clause 23? Because I don't agree, because sometimes it may prevail over the other. Sometimes, because when there is a clear statutory kind of a definition of lien, it speaks about the rights of the contracting party to exercise lien over a property of a third party. And when you say a man-made clause under clause 23, do you think that the provisions under the common law principles will prevail over clause 23?
No, it is a very submission that when there is a contractual relationship between two parties, it is the remedies under such contractual arrangement that prevail over the common law remedies. Therefore, in the present case, the ship owners could only have exercised contractual lien, and it is a very submission that contractual lien under the charter party dating 13 December 2023 is not incorporated into the bill of lading. Now, if the members of the tribunal peruse the incorporation clause, I may read for the tribunal, all terms and conditions, liberties and exceptions of the charter party dated as overleaf, that is the charter party dated 13 December 2023, including the law and arbitration clause / dispute resolution clause, are herewith incorporated.
Also, don't you agree with me? The law and arbitration clause is an independent contract, as opposed to this.
Yes,
Yes, but And so it is clearly says that the lien clause is so wide in its amplitude that it incorporates virtually every single provision of the charter party.
Sorry, sir, I didn't quite understand.
Doesn't the very fact that the lien clause even includes the non-arbitration clause, which theoretically is an independent contract, just shows how wide the amplitude of the lien clause of the incorporation clause is. My apologies. The incorporation clause is so wide that it incorporates virtually every single term.
Yes, sir, that was exactly my very next submission, that such wide language of incorporation will lead you to infer that all the clauses under the charter party are incorporated. But contrary to this, English common law construes the general words of incorporation narrowly. The same has been upheld in the case of the Jordan 2, where it was held that the scope of incorporation as such general words has to be construed narrowly in order to prevent excessive.
You know the facts of Jordan 2?
I'm not cognizant of the facts exactly, but I'm telling you the general ratio.
Then with fiat clauses, it deals with the obligation to load when it can be delegated by owners to charterers. Yeah, but that's besides the point. But I don't know how Jordan 2 deals with this with the incorporation part.
The judgment of Jordan 2 clearly said that the scope of incorporation by general words has to be construed narrowly in order to avoid excessive imposition of liability on the bill of lading.
But in that, if I'm not mistaken, in Jordan 2 it was incorporating the A rules or A dispute rules, not the terms of the charter party. I could be mistaken, but please tell me.
Even if there is confusion with regards to the Jordan 2 case, I would like to bring forth the case of the Portsmouth, where the test of germaneness was there. It was held in that case that according to the test of germaneness, the general words of incorporation only incorporate into the bill of lading those clauses which are germane to it, that is relevant to the context of the bill of lading.
Isn't the right of a ship owner to have security over his unpaid dues germane to the contract of carriage?
Such would be germane to the contract of carriage if there is an obligation to pay free or an obligation to make some payment towards the ship owner on the part of the claimant. In the present case, the bill of lading has been marked freight prepaid. Such a marking has been interpreted in the case of Cho Yang versus Coral Company Limited to mean that the consignor, and by virtue of series of endorsement, the consignee or the bill of lading holder did not mean to uptake any responsibility with regards to payment of freight or any other payments towards the ship owner. Therefore, by virtue of the negation of any obligation to pay, any payment under the charter party towards the ship owner, the lien clause is not incorporated, as such is not required, since we are not obligated to pay anything to the ship owners in the present case. Now, even if you reject such a submission, members of the tribunal, and hold that such general words of incorporation incorporate into the bill of lading the lien provision under clause 23, it would be subject to another restriction, as has been placed in the case of the Matthew, where it was held that conditions under a charter party have to be read verbatim into the bill of lading, and if such verbatim reading does not allow its operation on the bill of lading holder, they are ancillary to the context of the bill of lading. If I may ask the tribunal to please refer to the clause 23 of the charter party. Members of the tribunal, the clause clearly provides that the owner shall have lien upon all cargoes, sub-hired, sub-freights belonging or due to the charterers or sub-charterers.
But isn't all cargo and all encompassing?
Members of the tribunal, that very submission is based on the case of the Ignatius, which interpreted the clause 18 of the NYPE form. Now, if I may read clause 18 of the NYPE. Yes. Sir, a compendium has been provided to you. On the very first line of the compendium, there is a reference to clause 18. That the owner shall have lien upon all cargo and all sub-freights or any amount due under the charter. Members of the tribunal, now this very clause was when the NYPE 23 form came, was changed into the current form, which is the cargoes belonging to charterer or sub-charterer. That the interpretation that Mr. Arbitrator, members of the tribunal, due to the paucity of time, may I ask for an extension of 2 minutes? The tribunal, the clause 23 under the NYPE 23 form provides that cargo belonging to the charterer or the sub-charterer is the cargo that lien can be exercised upon. The very interpretation that Mr. Arbitrator gave referred to clause applies on clause 18, where there is not a qualification of cargo belonging to the charterer or sub-charterer. Now, members of the tribunal, the respondents may here argue that
Aren't the shippers sub-charterers?
members of the tribunal, shippers are not sub-charterers.
Why?
A sub-charter can only be, a person or an entity can only be considered a sub-charter when there is an explicit charter party between the charterer and
Yes, but does in law, as a matter of English law, for example, Indian law, does the charter party have to be in writing? Why has a shipper made payment of freight to your charterer?
members of the tribunal, there are
There is a contract of carriage. You may call it a charter party or not, but there is simply a contract of carriage pursuant to shipper's made payment of freight, right? So your shipper is effectively a sub-charterer.
members of the tribunal, contrary to this, we accept that there is a contract of carriage. But that contract of carriage is the bill of lading and not the charter party. There are two types of contract of carriage in the English law, either a bill of lading or a charter party. In the present case, the contract of carriage is bill of lading.
It could very well mean that there is an unwritten, the booking note evidences an unwritten voice charter party. So the sub-charterer needs anybody down the charter chain. It may not be a formal voice charter party agreement concluded, but I would imagine sub-charterer is a bit nebulous. It's vague, so you can definitely bring your shipper into it, given the fact that he's paid freight. And the fact of the matter is, you have no better right than your shipper.
Yes, members of the tribunal, but it is a very submission that a sub-charter can only be constituted when there is an explicit writing down of the sub-charter. Also, if the member
Yeah, but it says cargo owned by a sub-charterer, so the shipper is a sub-charterer, the cargo owned by a shipper is subject to a lien, and therefore you have whatever you get from your shipper is always subject to, you can't get a better case, I think, than your shipper.
I have an extension of one more minute to this. The tribunal, that is leading to verbal manipulation. Now, English case law provide for verbal manipulation in the case law of the Mera and the Anfield. But members of the tribunal, it is pertinent to note that the permissible degree of verbal manipulation has very clearly been provided in the case of the Miramar. They are reading directly from the judgment. Where a bill of lading, there is
That goes against you. Miramar was a case of demurrage. The person whose owner of the cargo was not liable for payment of demurrage. The House of Lords held that even though the owner of the cargo is not liable for demurrage, she is bound by the lien clause and the ship owner can continue to withhold delivery until the demurrage is paid.
Members of the tribunal, what we are referring to is the decision of the Court of Appeal.
No, the House of Lords. That is the final decision in Miramar. I am 100% certain about this.
As of tribunal, if I may refer to some judgment in the Miramar. And if you could come to the last page, if you could come to the last page of the compendium that has been provided.
Court of Appeal or?
And the tribunal, firstly, the Miramar came to the Court of Appeal, where the statement that Mr. Arbitrator just said was held. But it was overruled in the. It has been provided to the compendium. Last page of the tribunal.
One or two?
Last, just several compendium. Could you come to the second paragraph of the tribunal? Held that the consignees were not personally liable to the owners for demurrage by the incorporation of clause 8 into the bill of lading. The tribunal, it has been clearly held that they are not personally liable.
Exactly.
Yes.
It is no. I am not saying that you are personally liable. I am saying that notwithstanding the fact that you are not personally liable, they can still exercise a lien over the cargo. That's what it was saying.
That is where I would like to read this paragraph given in the Miramar. There in a bill of lading, there is included a clause which purports to incorporate the term of a specified charter party. There is not any rule of construction, to emphasis on not any rule of construction that the obligation under the charter party with the designation charterer is displaced in the bill of lading with the designation bill of lading holder. Verbal manipulation cannot be done in the present case since the Miramar clearly states that the designation charterer cannot be replaced with the designation bill of lading holder. Therefore, without any permitted verbal manipulation in the present case, it the lien is only valid over cargo belonging to the charterer or sub-charterer. Therefore, it cannot be exercised on the lien.
Which gentleman you are referring to?
Yes, the Myanmar. The last page on the complaint. Second last. If you will read the second paragraph. And the third paragraph also. So the third paragraph is very pertinent to our present case. The tribunal, this is an end of my submissions. If after reading there are no questions, I would like to pass the podium to my co-counsel. Am I allowed to do so, sir?
We get back to just one simple question and answer.
Yes, sir.
So are you agreeing to the fact that a shipper is a sub-charterer?
No, sir, we are not agreeing to the fact.
No, if the answer is no, why?
Sir, it is a very well established common law principle that a sub-charter can only be constituted when there is an explicit sub-charter in writing. There are two
So
types.
are you trying to say that every charter party has to be in writing? There can't be any evidence of the terms of the charter party?
There can be an implied charter party only when there is not a bill of lading. There are two types of contract of that. Either a bill of lading or a charter party. If there was no bill of lading in the present case, maybe the tribunal could have implied that there was a sub-charter party. But since there is an explicit contract of carriage in the present case, that is the bill of lading, dated 1st February 2024, the shipper in the present case cannot be considered a sub-charter. That fulfills the requirement of your question, sir. Thank you for your time.
Before that, one more question. See this Mirabar judgment. See Mirabar judgment. This is 1984. You are referring to the House of Lords judgment. Have you come across any appeal decision on the court? Sorry. No, Court of Appeal. No. This is the House of Lords.
It's the House of Lords.
It's the House of Lords.
Yes, the Myanmar. That
Do you have a copy of the appeal judgment?
But I do not have the copy of the appeal judgment with me, but that is the very copy of the House of Lords judgment, if I am right.
Yes.
Am I audible? Members of the tribunal, good afternoon. My name is Devakshi. As previously stated by my co-counsel Tanish Singh, I shall be representing the claimant, Vida Private Limited, in the present matter. In doing so, I'll be addressing the issues with regards to the rightful owner of the bill of lading and indemnity.
So first, come to our question, which I asked your colleague. How is it that you have title to sue under the English Coxa?
Members of the tribunal, if I could point you out the carriage of goods if I see that. Members of the tribunal, I would like to point you out to section 5 in this act, section 5(2) part A, which says that references in this act to the holder of the bill of lading are references to any of the following persons. Firstly, A, person with possession of the bill who by virtue of the person being identified in the bill is consignee of the goods to which the bill relates. Further, I would like to point you out to Annexure 3 of the Moot Compromise, which is the bill of lading. The part which states consignee states that Beta Private Limited, referring to themselves as a consignee, therefore section 5(2)(a) of the COGSA applies to the same.
Haven't you endorsed this bill of lading? By your action of endorsing the bill of lading, haven't you relinquished all rights?
Mr. Tribunal, this brings me to the second part of my first submission with regards to the bill of lading. I would like to state that the requisite conditions for transfer of possession of the bill of lading to Epsilon or Zeta have not been met. To this, I would like to first point out the 4 requirements for transfer of ownership or possession of the bill of lading, which are: firstly, the bill of lading must be transferable on its face. Secondly, the goods must be in transit. Thirdly, it must be endorsed by a person with good title.
Do you agree first 3 conditions are met?
First 3 conditions we concede on, and we don't have any contentions with respect to the same. However, I come on to the 4th and last contention, which says that endorsement must be accompanied by an intention to transfer the following goods in question.
Whose intention?
Members of the tribunal, it is intention of both the parties.
Oh, it's just your intention. The other parties, the bill of lading doesn't require another person to formally accept it. It is just your intention. So when you talk about intention, it is your intention to enforce it.
Members of the tribunal, to this, I would like to point out the case of Agency Traders Corporation versus Repsol Petroleum. If I could just give you a brief of the facts.
But as you know, in that case, that was totally inapplicable, because in that case, you are seeking to foist liabilities upon the consignee. And the consignee says that I am not liable merely because the bill was endorsed in my name. I never agreed to it being endorsed, and therefore I am not liable. Which is radically different from the facts of this case. What is taking place here is you have unequivocally endorsed it pursuant to a sale contract, and thereafter your buyer has not rejected the bill of lading. The buyer has merely said endorse it in the name of my subsidiary company instead of mine, and I have made a mistake, so you have not made a mistake. And effectively, right now, instead of you acting in accordance with the instructions of your buyer, you have misappropriated the bill by cancelling your endorsement.
Members of the tribunal, to this, I would like to respond by saying that as soon as Epsilon couriered the goods back to us couriered it back to us untouched, they denied any claim in the following goods.
Which is not correct, because you have already endorsed the same. You have already endorsed the same, isn't it? That means you have already cleared your intention and you pass on Teflon. And again, they said they have not rejected it. They said, look, please endorse the same to my group company, and then please send the same.
Members of the tribunal, I understand your question here, but however, I would like to point out that Epsilon and Zeta are 2 different companies and 2 different entities. Members of the tribunal, it is a subsidiary of the company, and therefore it is a completely entire legal entity in the present matter.
Had it been 2 different entities, I agree it's 2 different entities, but under one group, that is what the problem is, isn't it? So one group. Say, had it been 2 different entities altogether, probably we could accept your conditions. But here, this is one group. They have not rejected it. They said, look, please kindly endorse the same to my sister concern. I'm a group company. And they return the same. But endorsement has already done, correct?
You have abdicated your rights. Have they endorsed a bill of lading back to you?
No, members of the tribunal.
Exactly. So the bottom line is they have not rejected the documents. They have simply said, change the name of the party. And have you acted in accordance with their instructions?
Members of the tribunal, I understand the questions with regards to the bill of lading not being endorsed back to us. However, what we are trying to state here that for a valid transfer, there must not just be simply endorsement. There must be acceptance of the goods also on their behalf. And this has been again held in the case of Agency Traders Corporation versus Repsol Petroleum. While the facts of the matters may
Exactly, that's a case where you're trying to foist liability. They can always reject the goods. In this case, they have not rejected the goods. So that case does not help you. Can you give us a single instance where you endorse the bill of lading, and after having endorsed the bill of lading, you strike out your endorsement and appropriate the goods after you've endorsed it. You waive your rights, and after waiver of your rights, can you then revoke a waiver?
Members of the tribunal, to this I would like to point out to the moot company here. If I could refer you to paragraph number 5. You asked me when was the endorsement crossed out. To this I would like to reply that when we asked Gamma why hadn't they delivered the courier to us, they cited reasons saying that A, epsilon or zeta rather than beta is the lawful owner of the bill of lading. And second and third contentions are not relevant as of now. And if we move on to the next paragraph, beta, only on them telling us about these contentions on why they have not delivered the courier to us, we stated that beta thereupon crossed out the endorsement. So when they informed us that we, in their mind, we are not the rightful owners of the bill of lading, we crossed out the endorsement to epsilon.
Absolutely, so that they are perfectly legitimate because you under no, just merely because you hold the bill of lading at the highest, your position is that is a right of an unpaid seller. But the fact of the matter is, the property in the goods is passed on to your buyer. You can at the highest withhold your seller, stop your buyer from taking delivery of the goods, but you can't yourselves appropriate the goods. There's a radical difference. What do you mean by a right of an unpaid seller? Have you done some research on that?
Members of the tribunal, if I understand what you're trying to say, is that they were justified in withholding the goods to us?
No, that's not what my point is. My point is that your case pitched at the highest is that you are an unpaid seller. So an unpaid seller has also got a lien, the right of stoppage of transit. But once property passes, the property doesn't revest back on you. You get what I'm saying?
Members of the tribunal, if you could just clarify yourself once again.
So when the goods arrived in Singapore, the bill of lading was endorsed by you to your buyer, right? Your name, so it was impossible for you to take delivery to the cargo, and the carrier is not expected to look into your sale transactions, whether it went through or went not through. The carrier says that whose name the endorsement is there. You show the carrier at that particular point of time that these goods are endorsed to my buyer. The carrier says, I am not going to give it to you. Thereafter, 4 days later, you strike out the endorsement. Now, is this action an action in good faith? Because under COGSA 1992, you have to be the lawful holder of the bill of lading in good faith. Now, who gave you the right to strike out the endorsement?
Members of the tribunal, I would like to point out that though there may still have been the stamp of epsilon, there were 3 original copies of the bill of lading produced over here to Gamma Private Limited. And it brings me back to the question of intent.
You're not understanding my question. You may hold the original bills of lading, but are the original bills of lading in your name? Are you the party named as the consignee and the bill of lading, having already endorsed it to epsilon? You understand my question? Your case at the highest is you are exercising some sort of a lien against your buyer by holding on to documents of title so as to prevent your buyer from taking delivery of the goods. But that is not, you may at the highest have title, but you don't have property rights in the goods.
Members of the tribunal, this brings you back to my original submission. That endorsement is not the only or essential prerequisite for transfer. There must be an acceptance on the
as far as the carrier goes, the other side is a ship owner. A ship owner is casing. Let's take a simple case of a massive container ship like MSC, where you have say thousands of bills of lading issued on one single bill. Do you think it is the job of a carrier now to go to each of these 1,000 sale contracts and see who is the buyer, what is the sale transaction, is it lawful or not? The carrier has to look at a bill of lading. Does it have your name? On 10th, it did not have your name. Thereafter, on 14th, you strike. After having showed the carrier original bill of lading with epsilon's name, on 14th, you yourself cross it and say, now give it to me. The carrier is very well justified in saying this is not an act in good faith.
So, members of the tribunal, what you are asserting here is that it is not really the duty of the carrier to assert who is the rightful owner of the bill of lading here.
Yes, it is not the duty of the carrier to ascertain what happened in the sale transaction, whether the consignee accepted it or not, endorsee accepted it or not. The carrier simply looks at the bills of lading, on whose name it is endorsed, are you that party, you are not that party. On 10th, the carrier decides not to give it to you. And then on 14th, you strike out your name, the carrier feels this is not done in good faith and I am not going to give it to you. And he's eventually given it under indemnity of a bank guarantee which you have provided of 4.5 million.
Members of the tribunal, in fact, with regards to this point, I completely agree with you to say that they have no business or in fact even a duty to ascertain who the rightful owner of the bill of lading is.
But they have a duty to ensure that the bills of lading deliver the goods to the party named in the bills of lading. As on 10th of February, your name was not there in the bill of lading. And thereafter on 14th, you unilaterally cancelled your endorsement and they believe that this is not an act done in good faith.
Members of the tribunal, to this, I would like to draw your attention to the case of Glen Mills Curry and Company versus East and West India Dock Company. In this, it was stated that the carrier can deliver to the consignee knowing that he can later not be sued by conversion for a person who was actually entitled to possession at the time of delivery of the consignee. Thus, even if the claimants were not the lawful holders of the bill of lading, while we are contending that we were the lawful holders of the bill of lading, even if we were not the lawful holders of the bill of lading, the respondents had an obligation to deliver the cargo to them without the requirement of a letter of indemnity.
No, that's not necessary. They've got every right to protect themselves, especially now that there is a prima facie plausibility that they can be sued.
Members of the tribunal,
Because they feel this is you can't endorse a bill of lading and then strike out your bill of lading. That in some ways also perhaps amounts to or doctoring a bill of lading. A bill of lading is a sacrosanct document. Once endorsed, if you strike it out without the other party endorsing it back to you, you are appropriating goods in the bill of lading.
Members of the tribunal, this is what I am trying to assert here, that on production of 3 original copies of the bill of lading, the shipowner here is absolved from any liability which may arise from third party action.
No, not in tort. In tort, no.
Members of the tribunal, this has
can always be exposed to a tort of conversion. Because if he's knowingly participated in the fact of the matter is there is enough reasons to believe that the goods have been endorsed to X, that has not been endorsed back to you, and therefore there's a plausibility. I'm not saying it could happen, but there's a plausibility that he can be sued under a tort of conversion. So he's erred on the side of caution and asked for a bank guarantee of 4.5 million. Second point is you're not satisfied that you have property in the goods. How is it your goods? You've sold it to somebody else. The mere fact that you have not paid doesn't make your case better. Under the English Sale of Goods Act, please guide me through the English Sale of Goods Act and show me how is it that you own the goods.
Members of the tribunal, if I understand correctly, you were trying to ask me whether the sale of goods applies with regards to intention of the party?
No, just show me that you are the owner of the goods. Are these do you have ownership interest in the goods having already sold it? Merely because you have not got paid, does it mean you are continue to be the owner of the goods?
Members of the tribunal, this brings me back to the basic concept of contract law, for which there are 3 basic conditions with regards to completion of a contract, which are offer, consideration, and acceptance. In the present matter, there is no acceptance on behalf of Epsilon or Zeta, and therefore there is no valid
If the
contract.
contract has been concluded, they have not after having concluded the contract, they have told you to deliver it to their subsidiary company. But that doesn't mean, at the highest, they are reneging from a contract which is already concluded. But that does not mean, so theoretically, that does not give you the right to appropriate the goods unilaterally.
Tomorrow, probably you may go and chase behind the carrier, isn't it? There are possibilities for the misdelivery of cargo to the third party. It was not rejected basically, isn't it? Instead, rejection of the same, what they have done, you endorsed to my group company, that's all they said.
never said appropriated.
Members of the tribunal, the contention of the claimants here is that delivering the cargo back to the claimants without touching any of the bill of lading in the present matter constitutes as rejection on behalf of Epsilon Private Limited as an entity. The contention of the claimant here is that since there was no acceptance on behalf of Epsilon and Zeta is an independent company here in the present matter. This is the contention of the claimants that between Epsilon and Beta there existed privity of the contract and that contract had not been fulfilled.
What they are contending is there was a contract, they were the highest, asked you to vary the terms of the contract or terminated the contract. But that doesn't mean that there was no contract in the first place.
Members of the tribunal?
Do you have any other points to argue other than this?
Yes, members of the tribunal, with regards to this, you stated that vary the terms of the contract or change the terms of the contract. However, intention of the parties as referred under section 17 of the Sale of Goods Act only applies when there is an unconditional contract. In the present case, when there was such a big stipulation and a condition in the present matter, it cannot constitute as a valid contract since this was not an unconditional contract.
But just one last question. What does this mean? Beta immediately agreed to sell the cargo to Epsilon in Singapore at $461 per metric ton, immediately endorsing the bills of lading to Epsilon and couriering them to Epsilon. What does this mean? What does this indicate? Does it not mean that there is a contract? Why would I go and endorse goods worth 4.5 million to somebody when I believe that there is no contract?
Members of the tribunal, to this I have two responses. Leading you back to the Sale of Goods Act, in the present matter, this is an agreement to sale and not a sale. Agreement to sale, only when the goods are transferred or possession is transferred does the agreement to sale transfer to a sale. And secondly, if you could just peruse the next lines in the same paragraph. However, Epsilon then said that someone in their office had made a mistake and returned the bills untouched. What they are further contending is that this is a mistake with regards to one of the parties, and therefore this is a mistake of fact, rendering the contract void ab initio from the very beginning. Since when it is a mistake with regards to a party to a contract, this is not a mistake of law but a mistake of fact on behalf of one party, and this renders the contract void ab initio from the very beginning. Therefore, it is irrelevant whether there was endorsement in the present matter since the contract was void from the very beginning as there was a mistake with respect to the identity of a certain party. Members of the tribunal, my next contention was based on indemnity, which I have argued before you here, stating that they are absolved of any liability in case 3 original bills of lading are produced to them. Members of the tribunal, if I could just move on to my prayer now. Thank you for time, members of the tribunal. Members of the tribunal, so cost of extras of year, warehouse costs. Members of the tribunal, as of now, we have incurred. No. Does that satisfy the tribunal? Thank you for that.
But where have you shown your losses for damages? You just delivered 4 days later, and 4 days later you claim damages for late delivery.
Members of the tribunal, if I could answer this by referring the IISTL rules to you. The counsel for the claimant submits that since the bill of lading is governed by English law, the IISTL rules apply to the same. The rule's generic wording allows the court to create a trend of looking into delay in the context of loss or damage as used throughout the IISTL rules under Articles 6 and 7 of the rules. Therefore, what the claimant is trying to contend here What I'm trying to contend here is that throughout the Hague-Visby rules, loss and damages is referred in the Hague-Visby rules.
I don't think, show me which provision of the IISTL rules allows you to claim for late delivery. That too late delivery of 4 days.
Can you have a look at article 6?
Whatever is article you quoted, read it out.
Mr. Arbitrator, what I'm trying to contend here that throughout the Hague-Visby rules, loss and damage is referred to.
Yes, but where exactly to say that 4 days late delivery, you make a claim for late delivery.
Is it specifically mentioned in any of the convention?
As a tribunal to this, I would like to further proceed by saying that the counsels for the claimant submit that the respondents may argue since that there was no specific date of delivery of the cargo.
That we agree. That we agree. No dispute. Here the point is on what basis you are actually. Sorry. We are not disputing those facts. Agreed. 4 days there is a delay. But on what provision of law that you are claiming that 4 days, look at that point. What provision of law that you are claiming that? You can't simply claim it. Isn't it? On what provision of law you are claiming that 4 days delay?
And where in the complaint does it say you sustained a loss? You have to sustain a loss. Now, on 4 days delay, what is the loss you have sustained?
Members of the tribunal, with regards to your question, with regards to where have we sustained the loss, to this I would like to submit that, as you have stated, that the claimants may argue that the goods are imperishable and therefore no consequential loss may arise from the same. The claimants refute this assertion by arguing that mere delay in arrival of the goods cannot result in total loss of the goods, where assured has control over.
Does the contract have some liquidated damage clause which says that late delivery entitles you to compensation? That too late delivery by 4 days.
If you have Hague-Visby rules with you, just have a look at. I'm not sure. Articles.
Called the Kufas, which was also a case of sugar which was being late delivered into the port of Basra. And that was the first and only case where a ship owner was held liable for delayed delivery of goods. Also happened to be sugar only. But most of us lie in Iraq.
Was it for 4 days?
Yes, the ship was stuck because of the Iran-Iraq war for a long time.
See, in view of the contentions that you have taken for the time being, we were constrained to ask, one more question. See, you have asked for go down charges. On what basis you have charged go down charges, $1,200 per day? I'm sorry. They paid it. I'm sorry. They paid, but they are refunding. They are asking for the refund, isn't it? Yeah, they paid it under protest, but you are asking for the refund. On what basis?
Members of the tribunal, while we do not have any contention with regards to the cost of exercise of this lien, our contention here is the validity of lien in the first place on behalf of the respondents is
They have actually mitigated your losses. Had they kept the goods on board for those 4 days, they would have paid $46,000. They would have earned $46,000 in hire. They have done you a huge favor by not claiming that amount and putting it in the go down and just claiming $4,000, which is saving you $40,000. Instead of being grateful to them, you are now going and disputing such a claim, and nothing stopped you from giving that indemnity on 10th or paying this them on 10th. The fact of the matter is, you would have paid under protest then.
Members of the tribunal, we don't have any argument with regards to cost of exercise of lien. However, as my co-counsel argued, that the validity of the lien in the first place was invalid. So if the validity
you can see that if we hold that the lien is validly exercised, they are entitled to cost of lien. That's it.
Yes, Mr. That is what we are contending. Thank you. If there are no further questions.
Yeah, no, it's fine. I'm just thinking, I don't know whether you're right to concede that if the lien is valid, then necessarily the costs of the lien must be on you, be it on the ship or be it in the warehouse. You may have a more argument to say lien is correct, but not the costs of enforcing the lien.
With the tribunal, we would have had a contention if it was not for the case. Oh, yeah, that's the contention. Sorry, ma'am. Thank you for that.
approach the dais.
Am I audible, panel? Greetings to the panel. May I know who the presiding arbitrator is? Mr. President and esteemed colleagues, my name is Bianca and I am the first counsel on behalf of the respondents. I am assisted by my co-counsel Shivangi. I shall take 22 minutes and my co-counsel will be taking 20 minutes. I will address two issues. First, I would establish that Beta does not have the title to sue my client. Second, I would establish that Beta was not the lawful holder of the bill of lading on the date of delivery. Coming to the first issue, panel, in order to establish that Beta does not have the title to sue my client, I would like to ascertain the identities of the parties to the bill of lading. In the present case, the freight has been prepaid to the charterer. Panel, when the freight is prepaid to the charterer, the bill of lading is rendered the character of a charterer's bill of lading, which essentially implies that the parties to the bill of lading are the charterers as the carrier and the shipper and the shipper. So essentially, the original parties to the bill of lading are the charterer and the shipper in this.
But on whose behalf has the bill of lading been signed?
Mr. Arbitrator, as per the bill of lading on page 29, it is not clear on whose behalf it has been signed.
No, it is clear in the compromise. It says agents or an employee of the agents of the owner. So it's effectively, it is of our on behalf of your clients. And the second point, to just look at the charter party, look at a charter party which deals with the bill of lading, issuing the bill of lading. I tell you which clause it is.
Is it
31. Just read 31. 31A.
As per clause 31A, the master shall sign bills of lading or weigh bills of cargo as presented in conformity with the mate's receipts. However, the charterer or their agents may sign bills of lading or weigh bills on behalf of the master with the owners of the master's prior written
So you
authority.
agree with me that all bills of lading are issued in the name of the master? Even though it's issued by assuming it's issued by a charter's agent, but eventually under the charter party, it has to be issued in the name of master. So if a bill of lading is issued under the name of a master, does it become a charter's bill of lading or an owner's bill of lading?
Mr. Arbitrator, in that case, if the bill of lading has been issued by the master, since the master would be acting, if the master is acting under the instructions of the owner, then in that case, it would become an owner's bill of lading.
Absolutely. So in this case, it's an owner's bill of lading.
In order to answer your question, I would like to state that the signature on the bill of lading is only a prima facie indication. It is not a conclusive evidence as to the identity of the carrier. This has been laid down in the case of Vinyl versus Denner, and moreover, Ms. Panel, this is an unclassic form of FOB, which implies that we need to look at the entirety of the contract of carriage to ascertain who is the identity, who is the carrier in the present case. If I could explain my... if I could explain my submission, in an unclassic form...
What is an FOB contract?
Mr. Arbitrator, in an FOB contract, the shipper's liability ends when the goods are loaded onto the vessel.
Wrong. Who does the seller contract, in a FOB contract, does the seller enter into a contract of carriage or buyer enter into a contract of carriage?
Mr. Arbitrator, it is the seller who enters into the...
In an FOB contract, wrong, it's a buyer. Sorry, what am I saying? In FOB contract, it's a buyer. Yes, correct.
Mr. Arbitrator, as I stated before, this is an unclassic form of FOB, which implies that in an unclassic form of FOB, the seller makes the prior arrangements with the carrier. Now, in this case, there was a booking note that was issued between Alpha and the charterer, that is Delta. So Alpha made prior arrangements with Delta, which makes it the carrier in this case. Now, Mr. Arbitrator, in a FOB, in an unclassic form of FOB, essentially there is an antecedent contract to the bill of lading, which means that the booking note has to be read with the bill of lading. Now, if I could request your attention to the booking note on page 6 of the moot proposition. If the panel is with me, under the booking note, the signature of the carrier is not conclusive. So when the signature of the is not conclusive in the bill of lading and they are inconsistent with the booking
Is
note.
the booking note of any relevance in a dispute between the consignee and the carrier? I suppose I appreciate that as far as the shipper goes, the bill of lading is just evidence of the contract of carriage, prima facie evidence. The shipper can rebut it by reading further evidence like the booking note. But as far as the consignee goes, isn't the bill of lading conclusive evidence?
Mr. Arbitrator, I would like to submit here that the booking note is of particular relevance here because this is an unclassic form of FOB. In an unclassic form of FOB, the booking note has to be read with the bill of lading. So, since the bill of lading is issued in pursuance to the booking note in this case, the bill of lading indicates that the agent has signed it, but we do not know on whose behalf the agent has signed it in this case. Mr. Arbitrator, the principle as laid down in the stars in case is that the signature of the agent on the face of the document has to be given importance. Now, in this case, on the face of the document, it is not clear as to on whose behalf the agent has signed the bill of lading.
What are you trying to establish? Are you trying to establish that this particular bill of lading has been issued by the master or the agent or the employee? What exactly that you are trying to establish?
My exact submission in this regard is that since the bill of lading does not conclusively indicate as to the identity of the carrier, we need to look at the whole contract of carriage. Now, in the entirety of the contract of carriage, the freight has been prepaid to the charterer, which means that the bill of lading gets a character of the charterer's bill of lading. Since the bill of lading is a charterer's bill of lading, the carrier in this case is Delta. So, in this case, my client is not a party to the bill of lading.
You are trying to say that is the charter's bill of lading.
Correct, Mr. Arbitrator.
You don't want to say that this bill of lading has been issued by the owners as per the master, isn't it? That is what you are trying to say. It's a charter's bill of lading. Am I correct or not?
Correct, Mr. Arbitrator. As per the facts, we are not clear as to who has issued the bill of lading in this case. We are only provided with the fact that who has signed it. So, in this case, we cannot say that the master has issued the bill of lading in this case.
But you stop from contending that because your own charter party says that all bills of lading are issued by the master. It is a clear, that clause is effectively an identity of carrier clause which you read right now.
Is this contrary to that particular clause that you are trying to establish?
Mr. Arbitrator.
You can't go hot and cold at the same time. Either you may have to say that, look, this is conclusive by charter's bill of lading. Or you may have to substantiate that, look, these are the reasons in which we were constrained to argue that this particular bill of lading has been issued by the charterer, which cannot be construed as the order bill of lading.
I would then take the first rule.
You may have to stick on, you can't go hot and cold at the same time. Make it very clear. Because at the end of the day, if you want to take a decision, you may have to establish, if you want, your argument leads to, look, this bill of lading is not mine, it's charter's bill of lading. If that be the case, we'll consider that. But at the same time, if you want to establish that this particular bill of lading, if you have good interpretations, like this has been issued by the charterer, substantiate it. Because, which doesn't mean that it should not be correlated or contrary to the provisions of the charter party also.
I understand your concern, Mr. Arbitrator. I will then establish that the fact that the freight has been prepaid to the charterer is a conclusive evidence of the fact that this is a charterer's bill of lading. As per the facts, we are not clear as to who has issued the bill of lading in this case. Therefore, we need to rely on the fact that the freight has been prepaid to the charterer.
have paid the entire freight doesn't mean that. Don't you think so? Apply your mind.
Mr. Arbitrator, in that regard, I would like to reiterate that since the signature of the carrier is not conclusively indicative of that fact, we need to look at the entirety of the contract of carriage.
Now, what you're contending totally militates against all your other contentions. Number one, if you are not issued a bill of lading, if it is your charterers who issued a bill of lading, why are you insisting that they give you an indemnity of 4.5 million? You are not liable to be sued under the bill of lading. It's some your charterers were liable to be sued. So why have you acted unreasonably? This actually is an admission that you have arm twisted them for no rhyme or reason.
Mr. Arbitrator, if the tribunal should hold so, I would then proceed to my second submission.
Answer my question, madam.
We are not clear. You have to give a very clear-cut answer on this point. Like, are you relying? Which, if you say that, look, this has been issued by the charterer, you have to have a substantial points to answer. Otherwise, you must concede, look, this is honest bill of lading.
My point, and to add on to what my brother says, you have to answer my question. By that logic, you are admitting, tacitly admitting that there is no legal basis. You have acted totally irrationally and unreasonably by withholding delivery of cargo under pretext. Why have you insisted on 4.5 million? Without any bona fide, your actions is totally not bona fide. Because you are not going to be liable for 4.5 million. If your charterers are going to be liable for 4.5 million, you forced them to go out and give you a bank guarantee of 4.5 million, for which they have incurred $50,000 as costs. So you can see that is wrong.
Mr. Arbitrator, the charterers in this case are insolvent. So my client was.
So it's all the more better for you if let the third party go and sue an insolvent party. How are you affected? You claim that you have not issued a bill of lading. Therefore, there is no exposure of liability from your end, from the holder of the bill of lading. So, what is the justification of asking them to provide you an indemnity bond of 4.5 billion?
Because, Mr. Arbitrator, we had a reasonable doubt as to the identity of the lawful holder of the bill of lading.
Yes, but if you assuming you've delivered it to a wrong party and they are not a lawful holder of the bill of lading, even then you are not going to be exposed to any liability under the bill of lading. It is your charterers who are going to be exposed to liability. So why have you sought 4.5 million as indemnity bond from them?
Mr. Arbitrator, we would still be exposed to the liability because the charterers in this case have gone insolvent. So any potential claims.
If the contractual counterparty under the bill of lading is the charterers, how are they going to sue you as head owners? As a matter of English law, there can be only one carrier under the bill of lading. And in this case, by your own admission, the carrier is the charterers. So you have absolutely no exposure to liability. So your actions of demanding that they provide you 4.5 million as an indemnity bond is totally unreasonable and totally illegal.
Mr. Counsel, let the third party file a suit against the charterers. Why should you bother?
It's like this. Suppose I believe somebody is going to make a claim of 1.5 million against my brother, Mr. Shankar. And I say, I want you to give me an indemnity failing which I am not going to give you your goods when I am not liable for the claim. You're not here to espouse the cause of your charterers.
Mr. Arbitrator, yes, Mr. Arbitrator, if I could address your concerns, the question that I gather is that since the question is that I am not exposed to any liability because they should have proceeded the charterers instead.
If you are not exposed to any kind of liability, then why did you insist them to file indemnity?
I'll just let you know where sir. 3 points in your favor and 3 points against you. The ones in your favor to try and help you to answer the questions is you're not responsible because the BL set freight prepaid. The only person who could have, only you got paid, only under this fixture note was prepaid, nothing under the time charter party. So therefore, the carrier was the person who received the freight, not the head owner, because he never received any freight. He was to receive hire. That is one answer. Therefore, the carrier is the person who received the freight, not the person who did not receive the hire. First argument. Your second argument to help you is that the words of the bill of lading are ambiguous. If it was an owner's bill of lading, it would have said signed by master to help you.
Correct, Mr. Arbitrator. That was my submission.
Third argument to help you is merely because I took a letter of indemnity does not mean that I am not liable. Tomorrow somebody like this tribunal may have come to a conclusion that it was to protect that risk of yours, therefore you took this letter of indemnity to protect yourself in this uncertainty. Three arguments against you, which is what they are wanting answers from you is, one is that the charter party specifically says that it's going to be a master's bill of lading or a head owner's bill of lading. Two is that you took a letter of indemnity, so obviously you are exposed to liability for misdelivery. Three is you exercised a lien, and you can't exercise a lien if you are not the carrier. And four is you even collected money also, which was the unpaid hire by virtue of exercise of this lien. And now when you are being sued, you are disclaiming being a carrier and therefore don't want to return the money.
Yeah, my brother is the guardian angel for you. So.
Mr. Arbitrator, if I could elaborate why my client seek the letter of indemnity from Beta in this case. Mr. Arbitrator, Beta in this case wanted to further sell this goods. So we acted in good faith and discharged the goods on letter of indemnity because we did not believe that they were the lawful holders of the bill of lading. Secondly, if we kept the
if you genuinely believe they are not the lawful holders of the bill of lading, then why did you give them the goods in the first place?
Because Mr. Arbitrator, that's how a letter of indemnity works.
No, if the law under Jug Ravi, a very famous English court judgment is, even if a letter of indemnity is issued towards you, and you knowingly, willfully deliver goods to a party not who you know is not the owner, that letter of indemnity is invalid because that is a fraud.
Mr. Arbitrator, I was not aware of the same. My understanding of the letter of indemnity was that it is when the letter of indemnity is claimed when the shipowner believes that the person claiming the goods is not the lawful holder and therefore they can discharge the goods while asking for the letter of indemnity. Mr. Arbitrator, to address the concern.
You can move on to the next point.
Mr. Arbitrator, if I could then proceed to my argument pertaining to the lawful holder in this regard. I would like to state that Beta was not the lawful holder of the bill of lading and it was Epsilon because the goods were sold in transit to Epsilon. Now, Mr. Arbitrator, when the goods are sold in transit, the property in the goods passes to the buyer. In this regard, I would like to rely on the sections of Section 17 and Section 18 of the Sale of Goods Act of the United Kingdom. As per Section 17, the property of the goods passes when it is intended to pass. Secondly, if we read this section along with Section 18,
here they have rejected the documents. Their actions of rejecting the documents revest the property back in the seller. They have rejected the contract of sale is terminated.
No, Mr. Arbitrator, because the goods have already been sold to them, so that the contract of sale was concluded at that particular point of time.
Yes, fair enough. But is it not the case that the liquidator of your buyer has categorically abandoned the goods?
Yes, Mr. Arbitrator, that supports my contention that till 15th February 2024, the liquidator of Epsilon still had interest in the goods. So we did have a reasonable suspicion as to the fact that another party could have come forward and claimed the goods.
So are you willing now to return the indemnity back to them? Because now you believe that no other party is going to make a claim against you. 1.5 million bank guarantee which they've given you, you are willing to give it back because now you believe that there's no way you're going to expose to liability from Epsilon.
Yes, Mr. Arbitrator, then in that case, I would concede to that claim. However, I would then not concede to the other claims.
If you concede, you finish. Don't do that.
Mr. Arbitrator, in this regard, we would still have the other claims pertaining, we would still have the cost of charter hire that we have already recovered, as well as the go-down rent that we have recovered from the claimants in this case. Mr. Arbitrator, moreover, in this case, Beta did not have a better title to the goods until it crossed out the endorsement in this case. Because Beta was an unpaid seller in this case, it came forward to exercise its right to stoppage in transit and took the possession of the goods. Thereafter, it got the right of resale. So, when an unpaid seller exercises the right of stoppage in transit, only then they get the right of resale as per the Sale of Goods Act. Therefore, they get a better title of the goods. This explains the fact that why they cancelled out the endorsement only on 14 February 2024 and not before. Mr. Arbitrator, my client was not supposed to go behind the documentation and inquire as to how they got the possession of the bill of lading. If my client saw that the endorsement on the bill of lading was made in favor of Epsilon, we were entitled to discharge the goods only to Epsilon in this case. This has also been laid down in the case of East-West Corporation, where it was held that the carrier is not, that the ship owner is not supposed to inquire and go behind the documentation to ascertain how the possession of the bill of lading came into the buyer in this case. Moreover, lastly, I would just like to state that the endorsement to Epsilon in this case was irrevocable. As per Section 5, subsection 2B of the Act, the Cox Act of the United Kingdom, Mr. Arbitrator, if I could just take a moment to summarize my submission.
COXA 5.2.
Yes, Mr. Arbitrator. Mr. Arbitrators, as per Section 5.2b of the Cox Act, a lawful holder is a person with the possession of the bill as a result of completion by delivery or endorsement of the bill, and this delivery as per the Sale of Goods Act, as per Section 61, is a voluntary transfer of possession. Moreover, Mr. Arbitrators, after such delivery, the endorsement becomes irrevocable. And when the bill of lading is endorsed by adding a sign or any instruction, which in this case has been written that it has to be the bill, Beta endorse the bill of lading.
I have a question.
Yes.
Seller sells goods to buyers. Okay, the bill of lading with there's some pre-shipment damage in the goods, and the master clauses the bill of lading. You know what clausing the bill of lading means, right? It says that there is some damage to the goods. Thereafter, the documents are provided to the buyer. The buyer rejects the documents. So the bill of lading is endorsed to the buyer, and the buyer rejects the documents. Now what happens to the seller? Can't the seller take delivery of the goods because given the fact that the buyer has rejected documents?
Mr. Arbitrator, in that case, yes. However, in this case, the buyer, that is Epsilon, did not reject the goods. They simply stated that the goods should be that the bill of lading should be endorsed to their subsidiary instead. So there was no rejection that
They have rejected documents. They have disclaimed any rights under the documents. You have not, so the subsidiary today can't sue you because it's not endorsed in the name of the subsidiary. It's only Epsilon who can sue you. When Epsilon has categorically relinquished any claim, who is the party who can sue you? There's nobody else who can sue you under the bill of lading.
If Mr. Arbitrator could grant me an extension of 2 minutes, could Mr. Arbitrator rephrase that question?
You are the only party who could potentially sue you under the bill of lading is Epsilon, right? There's no other party. Given the fact that they return the bill of lading to you, can they thereafter sue you? Return the bill of lading to their seller, my apologies. Can they sue you, the carrier?
Yes, Mr. Arbitrator.
Under what provision of law? Haven't they abandoned their rights towards the goods? They can't even sue you in contract, they can't sue you in tort.
I would like to provide 2 reasons for the same. Firstly, the property of the goods has been vested with them. They are the owner of the goods.
Fair enough, but they have relinquished proprietary interest. So when they relinquished, they are stopped today from suing you, the carrier.
Mr. Arbitrator, the fact that they returned the bills of lading would not transfer back the rights of suit to Beta in this case. The mere redelivery of the bill of lading to Beta in this case would not imply that they have relinquished their rights or they have transferred the rights of suit back to Beta. Mr. Arbitrator, if that satisfies your question, I would then like to conclude my submissions. Thank you, panel. Now my co-counsel will elaborate on the rest of the issues.
May I approach the podium?
Greetings to the esteemed tribunal. I am the second counsel for the respondents Gamma. I will be addressing the issue of the validity of lien as exercised by my clients, and that they are not liable to pay back.
The first question is, if you have not issued a bill of lading, how can you exercise a lien over, rely on a contract to exercise a lien? Answer this question first.
So we are not relying under the contractual lien to get.
You concede you don't have a contractual lien against the cargo, that you concede.
So, Mr. Arbitrator, yes, we do not have a we cannot.
What is the legal basis by which you are exercising a lien?
So we have a bailment relationship with the consignees here.
As a tribunal, can we adjudicate on issues other than contract?
Yes, sir.
Under what provision? Where can we adjudicate non-contractual disputes? This is not within the remit of the arbitration. This dispute is not arbitrable and not within the scope of arbitration agreement.
Sir, Mr. Arbitrator, to answer your question, torts are arbitrable as this was held in the.
Torts are arbitrable provided there is an agreement between the parties to refer the tortious dispute to arbitration.
So even though we are not the original parties to the bill of lading in this case, which is the charterer Delta.
In cases you were never a party, not original party.
Yes, sir, but so we are actually exercising this lien over the cargo. So we are actually exercising this lien over the cargo because there was notice to the same given to Beta by the incorporation.
When did you give notice?
So when we issued the bill of lading, when the bill of lading was issued to Beta in this case.
You didn't issue the bill of lading to Beta, you issued the bill of lading to Alpha. Alpha in turn gave 10,000 to Beta. Beta in turn, okay, but that's a different point.
Mr. Arbitrator, to answer your question.
But the point is, you had a right to intercept subfreight. Are you aware of the right of intercepting subfreight under the Charter Party? Which provision on Charter Party allows you to intercept subfreight?
The clause 23 of the Charter Party would allow me to do that.
Read that out, please.
Yes, sir. So clause 23, if I may take a moment. Sir, it reads, the owner shall have lien upon all cargoes, sub-hires and sub-freights.
How do you exercise lien over subfreight?
So we exercise lien, so we, as owners, we can exercise lien over the sub-freight when the hire is unpaid in this case.
No, you exercise lien over subfreight by writing to the shipper that pay me the freight which you would, but for my notice, pay to the charterers, failing which you will have to make payment of freight twice. That is how you exercise lien over subfreight. You have waited for the ship owner, for the shipper to make payment of freight. So you have no right to now exercise lien over subfreight in the first place. So there is no liability, contractual liability from the claimant towards you. You agree with me?
Mr. Arbitrator, that is the reason why I do not want to go under clause 23 of the time charter to exercise lien, because of the fact that the freight was prepaid to the charterers in this case, and this is a charterer's bill of lading. The owner's lien over the subfreights will be extinguished. So I cannot exercise the lien over subfreights.
You would have exercised the lien prior to payment of freight. But yes, you are right, because the bill of lading says it's freight prepaid, it's different. Yes.
So that is the reason why I want to claim lien over the cargo on the terms of bailment.
Okay, so but where in law can we adjudicate your terms of bailment? We are a creature of a contract. We can only adjudicate disputes under a contract. You have a claim in bailment, you sue them in go to Singapore and sue them in the forum there. So
Mr. Arbitrator, to answer your question, if I may explain how bailment has occurred in this case, because of the fact.
You're not answering my question. I'm not disputing that bailment has occurred. I am asking you, give me some law to show that we can adjudicate a non-contractual dispute which is not within the scope of the reference to the tribunal. We are a creature of a contract. We are not a court of law.
Mr. Arbitrator, to answer this particular question, if I may explain how the bailment actually occurred in this place so that I can answer this.
Even assume for a moment we agree on the bailment terms. The point is whether we are competent enough to stop your argument in terms of contract or bailment.
Yes, sir.
Whether this tribunal is competent enough. Would
So,
you think that it is beyond the scope of arbitral?
the clause 54B of the time charter says that the arbitral tribunal can adjudicate the disputes that are arising out of or in connection with the arbitration agreement. So
Does it mean that the contract of bailment, the argument on the contract of bailment can be adjudicated by this arbitral tribunal?
So, if I may rely on a case, Fiona Trust, which is a UK High Court judgment, it says that the words arising out of or in connection with the arbitration agreement.
You know the facts of Fiona Trust? I'll tell you the facts. The contract was concluded by corruption. And there was an issue whether the underlying contract is void or not. The English House of Lords said that it is for the tribunal to decide that. So that mere fact that the contract is procured by corruption was irrelevant, irrelevant to the facts at hand.
No, but the principle in this case clearly said that arising out of or in connection with the arbitration agreement.
You may have to establish you correlate.
Are you party to the arbitration agreement?
So, we are party to the arbitration agreement in this case.
How can it be? Where is arbitration clause in that case?
So, in the case of Fiona Trust?
In our case.
Yes, sir. Sorry, sir. In our case, clause 1 of the bill of lading incorporates the.
Are you a party to the bill of lading?
No, sir, I'm not a
So
party.
you're not party to the arbitration agreement?
Then how can clause 1 would be made applicable to you?
Yes, sir. It will not be applicable.
So this is not arbitral.
So, but if
The issue cannot be arbitral then, isn't it?
You go to Singapore, sue them in Singapore, whatever you want.
Go on with your point about
So if I may explain how bailment occurred in this particular
We
case.
concede there is bailment. Nobody, no dispute on that. Go hold their cargo. But that's not our question.
Better you concede this and then move on to the next point. I think that would be a better option for you. Correct. See, you got your pointers. See, we have no objections. I mean, we are convinced about your point on the contractual bailment. But our only concern is whether this arbitral tribunal is competent enough to handle on that particular issue. Because you are not competent.
Mr. President, to answer your question, I still think that the arbitral tribunal is competent enough to.
Go ahead. We'll hear you. Go ahead.
Yes, sir. So, in this case, bailment actually happened because we implicitly got the possession of the goods when we were carrying them in the vessel.
You actually have possession. You're disputing that.
Yes, so we have possession of the goods, and that is how we are the bailey of the goods. So when there was an unpaid charter hire amount by the charterers, we exercised the lien over the cargo, and that is how we obtained the charter hire amount from the claimants in this case.
But the issue is, even assuming bailment applies and we have jurisdiction to decide this if you believe you don't, can you exercise a lien over some third party's cargo which is not related to your claim? It's some unknown third party.
So, Mr. Arbitrator, to answer your question, they are not an unknown third party. We were carrying the goods in our vessel. So, because we are the ship owners of this vessel, even though the carriers are the charterers in this case, we are the ship owners. We were carrying the goods on our vessel. So, we had the possession of them, and that is how bailment occurred in this case. And As bailees of the goods, we exercised lien over the cargo when there was unpaid charter hire amount. We obtained 3,51,667 from the claimants for the unpaid charter hire amount. Sir, also, we
I would call it extortion.
Anyway, go ahead.
Mr. Arbitrator, to answer your question, this is not extortion because we were, the charter hire was unpaid by the charterers in this case, and we exercised it over the goods of the claimants, and we can do that because we are going under the common law lien, that is the bailment, and we are not contending to go under clause 23 because we do not have the rights to do that in this case because the freight was prepaid.
Cutting long story short, we do concede the fact that the contract of bailment, your argument of the contract of bailment, we agree, we are not disputing the fact. But please enlighten us with some substantial document, some judgment, wherein this arbitral tribunal is competent enough to handle your argument, this as an issue, if you have. The other judgment cannot be made applicable. My brother has already made it very clear on that point. If you have any other judgments to prove or substantiate that, look, this particular issue is, the arbitral tribunal is competent enough to handle this issue, I mean this particular argument. According to us, we are not competent enough.
Mr. President, I do not have any other judgment. I was relying on the case of Fiona Trust to argue that the clause is wide enough.
My brother has already made it very clear. Even the facts also is clear. So that cannot be made applicable in this particular case.
Mr. President, to answer your question, the facts that Mr. Arbitrator decided, like he elicited in front of me right here, they actually support my case in this favor because in that case it was held that a claim like fraud could be adjudicated by the arbitral tribunal in this case. So fraud could also be a tort in this case. Now, if we go under common law, bailment can also be adjudicated.
Alright, so you are giving a wide interpretation to that judgment, and then you are trying to establish that if that can be adjudicated by the tribunal, you are giving a wide or rather wide interpretation to that particular judgment, and then trying to convince us that this arbitral tribunal has complete power to consider your argument in terms of contract of bailment. Am I correct?
Mr. President, yes, because the clause 54B of the time charter clearly says that it can include, the arbitral tribunal can adjudicate on disputes arising out of or in connection with the arbitration agreement, the main contract. So because of the wide interpretation.
Yes, exactly.
What are the defendants to this matter? No? You should be objecting to jurisdiction. That's why I think you are finding yourself struggling to defend jurisdiction. Because on the one hand you are saying you are not bound by the time charter. Defendant maintaining jurisdiction of a court.
Anyway, see, my brother is always a guardian angel for everyone. What I would suggest is you just switch over to the next point. We are convinced.
Yes, sir.
Make it switch over to the next point.
So with regard to the go down rent, that is $4,800, my clients are entitled to the same because when we discharged the goods into the go down, we took good care of them. It was for only 4 days, but these goods were not damaged in any way. And because of the fact that we were baileys, we took reasonable care of them and we are entitled to the same. As yes.
Haven't you parted with possession? You said you have possessory lien. Now, the
Yes,
moment
sir.
you discharge goods into a go down, your possessory lien goes. So, as on date, when they made payment under protest, you never had possession of the goods.
So we had possession of
How did you have possession? Was it in your vessel? It was in another go down owned by a third party. That party has, you have no possession of the goods. So, your exercise of possessory lien, they are entitled to refund all the amount which they paid you. Because firstly, you never had possession.
So we had possession of the
On
goods.
the date of 15th, when was it? 14th of Feb.
Yes, sir, 14th of February.
Yes, you never had possession on 14th of Feb. You relinquished it on 10th when you voluntarily, without anybody's involved, asking you to do, go and put it into a warehouse.
So So we had possession of these goods till 14th of February because
How is it in your custody?
so they are in my custody. I discharged them into
Yeah, but they're in a warehouse. They're not in your vessel. You don't have. What is meant by possession?
so possession is when I can exercise control over the goods.
Yeah, but when you give it to a third party, can you exercise control over the goods when it's not in your custody?
So they are in my constructive custody because I discharged them into the godown, and it was on my orders or actions that it was discharged in the godown. So because we took reasonable care of these goods till the DN was discharged by the claimants in this case, we for the reasonable care that we took of this cargo, we would like to ask for $4,800 in this case. So lastly, with the delay in delivery, the claimants here claim delay under the Hague-Visby rules, but under Article 3, Rule 6 of the Hague-Visby rules, where loss or damage can be claimed, it can be claimed. It is not very clear as to economic loss can be claimed. There are different interpretations to the same, but notice has to be given to the other party when you're claiming the damage. In this case, we got no notice of the same, so they cannot rely on that. So
Read that clause of Hague-Visby which you quoted. Just read it out now, please.
So I do not have the compendium with me. It is in the first compendium.
You have that Article 6, you have?
So it is, yes, it is there. I can open. Yes. Yes. So, with the other point that the claimants have relied on the case of the Heron 2, so in that particular case, the delay was for 9 days, and that is why they got the damages for the late delivery. But in this case, it was 4 days, and we took reasonable care of these goods. Sir, also, so if I may read Article 3, Rule 6. So it says, unless notice of loss or damage and the general nature of such loss or damage be given in writing to the carrier or his agent at the port of discharge before or at the time of the removal of the goods into the custody of the person entitled to delivery thereof under the contract of carriage, or if the loss or damage be not apparent within 3 days, such removal shall be prima facie evidence of the delivery by the carrier of the goods as described in the bill of lading.
Yeah, but where does it talk about economic losses? It says that if you don't protest within that period of 1 week, then the goods have been delivered in good order and condition.
But sir, in some cases,
So where did it say what you're trying to say, that you can't recover loss, business interruption losses or economic losses? It says you have to notify us of the loss you sustained.
But so the claimants did not notify us of the.
They have taken it in 4 days. The goods, they have taken custody of the goods immediately in 4 days, so that doesn't apply. Read it again, please.
So the next clause says, if the loss or damage is not apparent, the notice must be given within 3 days of the delivery of the goods. So, unless notice of loss or damage and the general nature of such loss or damage be given in writing to the carrier or his agent at the port of discharge before or at the time of the removal of the goods into the custody of the person entitled to delivery thereof under the contract of carriage, or if the loss or damage be not apparent within 3 days, such removal shall be prima facie evidence of the delivery by the carrier of the goods as described in the bill of lading. So, in this particular case, they did not give us a notice. Also, the fact that we took reasonable care of the goods. Sugar is a non-perishable item. It is a dry cargo. It won't be damaged when we keep it in the godown in an airtight situation, and there were no economic losses that were caused to them. They are still asking for a delay in delivery of $3,000. Sir, if the members of the tribunal have any other concerns, I may answer them.
You are the one who has actually asked for the, you are the one who has actually claiming for the charges for the go down, $1,200 per day. On what basis?
So we are claiming for them because we took reasonable care of the cargo, as I mentioned earlier.
As my friend already clarified that you lost possession. I mean, you have already discharged the cargo. Then on what basis then you can charge it?
Sir, my clients did not discharge the cargo until the lien, the unpaid charter hire amount, was paid by the claimants in this case. That was up on 14th of February.
What makes
They discharged on 10th of February, deliver the car.
see, it makes difference between discharge and delivery. Your client discharged the car.
So, but yes, I'm aware of the same that yes, we did discharge
What
the
makes the
cargo, but
difference? What makes the difference between a discharge and a delivery?
the discharge of cargo is when the vessel has reached the port and there is a discharge of the cargo. Delivery is when a person comes forward to claim the delivery, or the delivery is given to the person who comes forward to do it. But I have possession of the goods until Beta came forward to claim the delivery in this case.
Once deliveries happen, then the title passes along with him.
Yes, sir, it does, but we want to claim for those 4 days.
Once DO, delivery order is issued, the title of the cargo automatically passes along with the cargo to that particular person. But the discharge doesn't happen.
So, in this case, claimants did get the title of the cargo in this case, but we're claiming the godown rent for the 4 days in which we took care of the goods. Because even after discharge, till the delivery, there was some time that we took care of the goods. So $4,800 is for that, because as Baileys we were taking reasonable care of the goods. So if I may summarize my prayer. Yes, sir. So we would like to claim that this arbitral tribunal holds that the charter hire amount that we asked from the claimants was lawful, as the lien was exercised lawfully. Secondly, the $4,800 for the godown rent as claimed by us is lawful. And lastly, we are not liable to pay them for the $3,000 for late delivery. Thank you, members of the tribunal.
You want? How much time do you want?
Just for information, they have reserved 2 minutes for rebuttal and they have reserved 3 minutes for that.
Yes, you can find 2 minutes.
Yes, sir.
You will also confine to 3 minutes.
Members of the tribunal, the respondent's only claim to challenge our title to sue in the present case is that the bill of lading has been marked freight prepaid. Members of the tribunal, it has been very clearly held in the case of the Rosalind that marking a bill of lading freight prepaid does not negate the contract between the ship owner and the bill of lading holder. Its only function is it prevents the ship owner from imposing any obligation with regards to the payment of freight on the holder of the bill of lading. It does not negate the contract. It only prevents it from imposing an obligation regarding the payment of freight.
Challenging your title to sue because of freight prepaid. That's not my understanding there.
The tribunal, in the present case, they've considered that we have a title to sue, but even their only conclusive argument that the tribunal rejected, that we are reiterating, is freight prepaid does not negate the contract. Marking freight prepaid does not negate the contract.
That's okay.
Secondly, members of tribunal, this tribunal does not have the jurisdiction to accept their justification of lien on bailment. Since this tribunal is a creature of contract, they have to satisfy this tribunal that the contractual.
That also they are convinced.
Yes, sir. That is my only rebuttal. They have it.
Please.
Members of the tribunal, earlier the claimant brought to your notice that the freight prepaid term would not negate the fact that it's a charterer's bill of lading, and they relied on the case of the Rosalind. However, the case of the Rosalind that the claimants have cited in their memorial is actually an immigration case. It is a case of the Administrative Court of the Queen's Bench. They have relied on this case, which does not anywhere talk about the fact that the freight prepaid would negate the fact that it's a charterer's bill of lading.
Just give us that case.
We do not have the physical copy, but if you could use our laptop.
Secondly, the claimants contended that our argument on bailment on terms and that we would exercise lien due to bailment on terms would not be arbitrable before this court. However, we would like to submit that all claims arising out of under the charter party would be arbitrable, and that is the interpretation that has been rendered in the case of Fiona Trust. Members of the tribunal, we have provided the compendium, and in that case, the Fiona Trust judgment has also been provided. The particular line that reads is that all claims could be interpreted from the term arising out of. If I may continue, as per this case, the term arising out of or in connection with the charter party was rendered a very wide interpretation to include that all claims could be arbitrable. Therefore, we would like to submit that our argument on bailment on terms, and therefore we can exercise lien, is perfectly arbitrable before this tribunal. Thank you, panel.